Hi, I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. So today I'm going to talk about the collaborative process, but more specifically about who are the collaborative neutrals and perhaps how do you communicate with them. So let's start out first. The collaborative process is a neutral process by which the parties agree we're not going to take it to court. We're going to enter into a collaborative participation agreement. We're going to put together this team. Each of the parties, mom, dad, husband, wife, same-sex couple, they are going to each have a collaborative attorney. We don't call the attorneys opposing counsel like we do in litigation. They're collaborative counsel. But who are the neutrals? You're going to have two neutrals in the case. A financial neutral and a mental health neutral. Now, let's talk about the mental health neutral first. That's the person that's going to facilitate the meetings. That's the person who's going to go through the collaborative participation agreement with everybody there at the first meeting. They are going to talk about the collaborative communication agreement, other agreements, and kind of facilitate and lead the process. So they're called the facilitator, but they also are the mental health neutral. So they help the parties put together the parenting plan. They're going to talk to the parties about what's in the best interest of the minor children, what is co-parenting, what is shared parental responsibility, how to put together the number of overnights in the parenting plan and so forth. So very important, very helpful to the parties. The mental health neutral can also help the parties if they're dealing with some issues that are emotional in the case, if there's been adultery or there's concerns about the welfare of the minor children. All of that can come into play. The financial neutral is typically a CPA or a forensic accountant or some type of business valuation expert that is going to look into the finances of the parties. They're going to help the parties put together their financial affidavits. They're going to help the parties put together their mandatory disclosure, equitable distribution worksheet, child support guideline worksheet, and maybe an alimony analyzer worksheet, depending on if that's going to be an issue in the case. Okay, now, I think I've said previously in my videos on collaborative law, there is now a collaborative statute in Florida passed in the last couple of years, and there's also the family law rules that deal with collaborative that have been passed by the Florida Supreme Court. The Florida Supreme Court has said that in all family law cases, the family law attorney must give collaborative law as an option to the traditional litigation model. So the lawyer you're talking with, even if they're not collaboratively trained, is supposed to give that option to you. I'm not sure the exact percentage, but I think it's less than 10% of family law attorneys in Florida are collaboratively trained. So if you want to look into collaborative law and you're in Central Florida, we have the Central Florida Collaborative Law Group. Go to the website. I know the Tampa area has one. South Florida has a collaborative group, several collaborative groups. So that's really important. Okay, so the collaborative professionals in that first meeting, especially the mental health neutral, who's going to be typically standing up at a whiteboard or at an oversized Post-it, is going to write down the goals that the parties have that they want to achieve in the proceeding. So you should meet with your collaborative attorney ahead of time to really talk about what your goals are, because that's going to be super important. Now, there is one difference between the collaborative neutrals and the collaborative attorneys. The collaborative attorneys are still your lawyer. They're still have all of the rules regulating the Florida bar and the rules regulating confidentiality and the attorney-client privilege. So anything that you tell your collaborative attorney, you should know is completely privileged and is confidential. The new statute also provides for confidentiality for the documents that the financial neutral comes into possession of, or information that the mental health neutral comes into possession of. And it's very specific, but it does not prohibit the collaborative neutrals from sharing whatever the parties, mom, dad, whatever, have shared with them in a private meeting, because a lot of times you're going to meet with the financial neutral separately and the mental health neutral separately, and then that information can be shared with the collaborative professionals team, which includes the attorneys. So just be aware of that. If you're meeting with one of the neutrals, it's not the same level of confidentiality that it is meeting with your attorney. Okay, I want to emphasize here how important the neutrals are to the case. They are, just as it sounds, neutral. They're not biased. They're not favoring one side or the other. So it's going to be really important that the parties be transparent and provide all of the information that the neutrals need. If you have questions about confidentiality or the scope of communication with the neutrals, you should ask your collaborative attorney. All right, I hope this has been helpful. If it has, please hit that like button, subscribe to the channel, hit that bell icon. If you think this information would be helpful to anyone, please, by all means, share this information with anyone you think it would be of value to. Leave a comment below if there's a video you'd like to see me talk about. So any comment you'd like to leave below, I'd be happy to look at that and respond to it personally. So thank you so much for being part of the channel, and I will see you next time. Thanks. Bye-bye.